DNA evidence and DNA forensics is a miracle among itself. Um, it helps us convict. It helps us show that their suspects were there, but it also shows that our suspects were not there. And the advent of DNA evidence has helped exonerate hundreds of wrongfully convicted suspects, defendants in cases. Gary Dotson of Illinois was the first person exonerated by DNA evidence. He had been convicted of aggravated kidnapping and rape and sentenced to 50 years in prison. 6 years after his conviction, the victim recanted her testimony, claimed that she fabricated the crime and the offense. Yet the judge refused to hear a new trial, or refused to order a new trial. And eventually, Dotson's DNA was tested on the victim's undergarments and indicated that the semen did not come from Dotson, that it was somebody else. Kirk Bloodsworth experienced a similar fate to Dodsworth, and both of these guys, with a growing number of other defendants that have been wrongfully convicted because of error, eyewitness error, evidence interpretation errors, and DNA has been there to help free them and to set things right. As alluded to, the American justice system is not infallible, and innocent individuals have been wrongfully convicted. And we, as America, as a society, we have this belief that a person is innocent until proven guilty, and it is better to set free 100 guilty people than it is to send one innocent person to prison for a single day. Well, we have not been very good at that. And in 2013, I know this was a while ago, but based on your textbook, and I probably should go look it up to find out what the actual number is. But according to your textbook, the Innocence Project has assisted 311 people regain their freedom from wrongful convictions using DNA exonerations and using DNA evidence to prove that exoneration. Stephen Avery, if you guys watch the TV show, the Netflix series Making of a Murderer, it talks a lot about the Brady Bill, and it talks a lot about exonerations and DNA and how DNA actually got Stephen Avery out of prison. DNA has been invaluable in proving the innocence for numerous of wrongfully convicted individuals. Faulty DNA analysis has contributed to wrongful convictions by giving undue weight in evidence. And this has also been added to because of the public's view and watching all of these crime shows like NCIS and CSI and all of these shows, Criminal Minds, where DNA is tested overnight and they find the DNA tests and it's reliable and bad guys go to prison. Now juries are expecting to see DNA, and an unprecedented and unrealistic expectation of DNA evidence is being put on the DNA evidence, allowing for people to go free who don't need to, and to send people to prison who shouldn't be going to prison. So between slides, I went and checked the actual number. The Innocence Project has helped exonerate 367 people. That is as of today, November 18th, 2019. That's a lot of people to have been wrongfully convicted. On the other side of this horrible note are rape kits. It's estimated that there's anywhere between 200,000 and 400,000 untested rape kits. From the spring of 2019, I was the MC, Master of Ceremonies, of the Western New Mexico University Sexual Assault Awareness Day. And we talked to, and we had other people involved in this discussion on why there is such a backlog. The backlog is, all of these rapists could be running around free, continuing to rape. Serial killers and serial rapists are running free and at large because we have in upwards of 400,000 untested rape kits that all have DNA. The Debbie Smith Rape Kit Backlog Reduction Act in the Justice for All Act was established in 2004 as a way to provide federal funding for eligible laboratories to process DNA evidence and help alleviate that backlog. But that hasn't helped. This backlog is still outrageously horrendous. Texas alone had some 70,000 at one point, had 70,000 untested rape kits. And these rape kits have now been sitting for years sometimes. The evidence has degraded. There's all kinds of different possible problems. And the worst thing to discuss is the fact that while we're sending people to prison wrongfully, those people that have committed these crimes, these rapes and murders across our country are still free and running free because we have not tested these rape kits. That being said, testing a rape kit is extremely expensive. And judges may be reluctant to provide relief when challenges of invalid forensic evidence are called. Okay. Or trusting the jury to properly assess expert testimony. There are so many problems with these rape kits now that it's going to be hard to overcome them. DNA evidence was not generally accepted by the courts prior to State versus Woodall in 1989. However, the Frey standard, or the Frye standard, established forensic techniques and admissibility in court, and that was back in 1923. The Frye Standard determined the admissibility of evidence both in federal and state courts based upon the reliability. The Frye test has two prongs. The first is there a theory which is generally accepted in the scientific community which supports the conclusions that DNA forensic testing can produce reliable results? And second, are there techniques or experiments that currently exist that are capable of producing reliable results in DNA identification and which are generally accepted in the scientific community? The current law on expert testimony, taking Frye into account, was established under Rule 702 in the Federal Rules of Evidence. And then amended by the Supreme Court in 2011. And an expert witness may testify in the form of an opinion, which would normally be considered hearsay, if the expert's scientific, technical, or specialized knowledge will help the trier of fact to understand the evidence or determine a fact and issue. Okay. Second, the testimony is based on sufficient facts of data. The testimony is a product of reliable principles and methods, and the expert has reliably applied the principles and methods to the facts of the case. Okay. These are the rules for expert testimony. And as an expert testimony, if you meet these rules, you can evaluate a case. Dr. Keekbush is an expert witness for the use of force within a correctional institution. He's called to evaluate video evidence and interview evidence and to determine whether or not there was a use of force offense. My specialty and expertise is in extremism, polarization, hate groups, and the militia. Because I have sufficient facts and data based on the research that I have conducted, I can sit and make technical or other specialized opinion and present it to the court so that the court can make a decision on to what can happen. This is the same with DNA experts. So those science and scientists and those forensics experts who do nothing but study and research DNA every day can sit and talk about DNA and testify about their results. Wrongful convictions through false forensics have been illustrated throughout numerous research reports within the last decade or so. Cole, in his 2012 report, summarized two ways that wrongful convictions have been introduced through DNA evidence. First was as a tool for exposing miscarriages of justice in a way that allowed for bypassing debates over whether the alleged miscarriage of justice were in fact miscarriages of justice, and second, as a potentially important cause of the miscarriage of justice. Kind of what we've discussed here today is how DNA can contribute to not only exonerations, but to wrongful convictions as well. DNA evidence is a double-edged sword. The most recent case that we've been looking at and following over the last few weeks is Rodney Reed, who on 11/18/2019, the governor of Texas suspended his execution for 120 days because DNA evidence placed Rodney Reed at the scene of the victim. In fact, there was semen evidence to show that Rodney Reed had had sex with his victim. Other evidence has come up since showing and supporting that Rodney Reed and this woman were having an illicit affair and that the actual murderer was the boyfriend, the fiance at the time. The governor has asked for this case to be reinvestigated and to look into the aspects of the DNA evidence and how the DNA evidence was used to convict Rodney Reed. Okay. Gross and Schaefer in 2012 stated that accuracy is the key in criminal justice system. The most effective way to do so is by careful and honest, open-minded work before the conviction in the investigation and prosecution of criminal charges. It is important as criminal investigators, as criminal justice practitioners, that we use the tools that are available to us, but we have to be honest and open-minded and do all of the work and not pass off shabby work in order for the DA to get a conviction.